Welcome everybody to today's webinar where we're going to be exploring and doing a deep dive on service agreements and contracts in Xemplo for staffing and contingent workforce management employers. So my name is Reianna. I'm from our Xemplo product team, and I'm joined by Tim Stapleton, who's also from our Xemplo product team. Hello, Tim. And also Steve Forster is our employment law expert at Xemplo.
Hi, Ray. Hi,
Morning,
Tim.
Steve.
Hi, everyone.
So in today's session, we're going to be looking at what staffing contracts and service agreements are, the key benefits and uses of staffing contracts and service agreements for staffing contingent, client-based, project-based workforces, common risks of manual contract management and service agreements for everybody involved in the process, so the employer, the client, candidates who are working for the employer, and how Xemplo can simplify and safeguard that process for all of the parties involved. To start off our discussion today, first we're going to have a look at service agreements with Tim and Steve. So Tim and Steve are going to work through what is a service agreement, when you would use one, what they're for, how they fit into the overall onboarding flow. So let's hand over to Tim to take us through that.
Yeah, thanks, Ray. Look, service agreements is a really interesting part in the overall middle office space for a staffing and recruitment company. A lot of attention is typically given to the worker contract and the onboarding experience that they undertake as part of the transition, typically from an ATS system through the middle office, which is where Xemplo predominantly lives in these types of businesses. The service agreement, though, is a step which is undertaken in a number of different ways in a number of different agencies. We've found in our experience, and what it basically is it's a sign off of that assignment being initiated before it proceeds any way further through the process of the worker being onboarded and all of the things that come post that. So when we talk about service agreements, that's basically what we're talking about here as far as a document is concerned. What we're going to be covering off in this webinar is a lot of the fundamentals that exist around that contract, why it exists, why people should use them, how they differ from employment contracts, and how the two sort of work together in harmony to create a really strong compliance within your agency, and also to provide you a really good auditability of your documentation at any point in time when you want to go back and look at your assignments. So within the Xemplo platform, we provide the ability for you to store one or many service agreements, similar to the way that employment contracts are stored within Xemplo. The ability for you to have those service agreements as dynamic documents, which can feed in information directly from your ATS, such as Bullhorn. We'll talk more about that a little bit later on. But this is where you basically manage them and where you can upload them and where you can embed those merge fields into the document to make it a Xemplo dynamic document instead of being a static file, which it typically is in a lot of cases when these are sent manually via email. The components of a service agreement from a legal perspective is very important, and as I said, equally as important as an employment contract. So I might just hand over to Steve to run us through some of the components that make up a service agreement.
From a legal perspective, service agreements are important because they are the formal contract that exists between a staffing business and a host employer that define the commercial and operational terms for placing a worker at that host site. They precede and underpin any individual worker assignments. Why they're critical, legally speaking, is having clear, consistent service agreements is essential because they set the foundation for each placement. They do things like outline the assignment terms, including the role, location, duration, and reporting lines. So while that's ultimately critical to what you include in the employment agreement too, it's something that must be agreed between you and the host and how changes will be made to those arrangements before the actual assignment kicks off. It's also important to define the commercial relationship itself. You'll do things like include charge rates, margins, payment terms, what happens in the event of cancellation, for example, and what you need to do to resolve any dispute between the parties, because it's an unfortunate reality of all commercial arrangements that the potential for disputes is always there. Service agreements also allocate responsibilities between the parties. This is really important in the contingent worker setting where you have multiple stakeholders involved in managing things like worker safety, supervision, the provision of equipment, and compliance obligations. That naturally feeds into the mitigation of legal risk. As an agency, we want to be sure that we're not liable for the negligent actions of hosts, especially when it comes to circumstances where the day-to-day supervision is being carried out by that host. And just finally, by locking in, signed acceptance of pricing and scope before an assignment commences, you have much greater clarity in the unfortunate, but as I said, potential reality that a dispute does arise about those matters. So really can't understate from a legal perspective why for each assignment it is really important to have clear legal terms in place.
Thanks, Steve, for those great insights into why we would use service agreements for a staffing or contingent workforce management business. So the next thing we're going to look at is the concept of staffing contracts. I feel like I get the easy part comparatively to Tim and Steve because I think there's a good general understanding of what an employment contract is. It's essentially the same thing as a service agreement, but we're talking about the relationship between a candidate and an employer as opposed to the client and the employer. So probably the best way for us to talk about how employment contracts are managed in Xemplo is to take a look at it. So what I've done here is I've created a company in Xemplo, here a demonstration company. And this company we can see here is a staffing company. So that essentially means that we curate the assets that are available for this company to match the requirements of a staffing employer. So things like policy documents, contracts, etc., will all match the requirements of a staffing employer as opposed to a direct employer. So we have multiple content libraries within Xemplo, and this is essentially how we control which companies have access to which. If I jump into contracts here now, this is where I'll be able to build out a contract that is specific to a staffing company, so we can take a better look at what clauses that are potentially used in a contract and an employment contract for a staffing business and a candidate coming into that business would look like, as opposed to a direct employer. So now we're in a contract and we can see that it's been pre-populated with clauses that are specific to the type of employees that we're creating a contract for. That's full-time award employees engaged on an ongoing basis. So if you pick two of the clauses in this contract, we'll be able to see some of the clear differences between a direct employment contract and a staffing contract. So we have here a clause that is about bonuses, and we can see here some clear references to the fact that the client is involved essentially in the determination of when a bonus payment is going to be made. So Steve, would you be able to talk us through sort of essentially some of the differences here and why we have different clauses for staffing companies as opposed to a direct employer?
Look, thanks for that, Ray. I think that's a really good summary and introduction, and I'll speak to this clause in a moment. Safe to say that all employment contracts naturally need to deal with various key matters, including the nature of the engagement, the responsibilities and rights of each party, and the key terms regarding things like pay, benefits, hours of work, termination rights, just to name a few. However, as we know, there are some really unique features to contingent work that arise as a result of things like the dual direction or supervision that applies between a host and an agency, different WHS responsibilities, different arrangements around property and policy compliance, and the need to do things like address complexities with IP, confidentiality, and post-employment obligations where there's a labour supply chain. The specific clause that you've just homed in on concerning bonuses is a really good example of why this is such a beneficial tool for agencies, because it shows how we can deal with the unique features of contingent worker employment through the terms of this clause, but also emphasises how our continuous maintenance of contracts ensures you remain compliant. So if I just focus briefly on the terms of the clause that you can all see, it emphasises that when it comes to bonuses in a contingent worker scenario, the actual employer is usually not in a place or position to determine whether or not the conditions for a bonus have been met. That is because the bonus terms and conditions will usually be dictated to you by the client. So this clause makes clear that in the context of a bonus scheme, the role of the employer, the agency, is really to administer the payment following the client reviewing and assessing your eligibility or a worker's eligibility to receive a payment under a bonus scheme. It also goes further to specify that the actual bonus itself is only earned when the client deems that the worker has met the requirements for payment and the client has actually pre-funded the company for that payment. Now, obviously, tweaks can be made to this, but that is a clause that's specifically intended to protect agencies and to prevent them from ending up in disputes with employees around bonuses in circumstances where they're not in control of that process. I would just add to this, if I could, that this is a good example of how Xemplo's approach to maintaining contract clauses is really important. You'll see that there's a line there that says, for greater certainty, for the purposes of your employment with the company, any payment due under this clause is only earned for the purposes of the Fair Work Act once the conditions in A and B above are satisfied. That's a recently included addition to this clause, and we've done so to respond to a very recent specific federal court decision that has found that deferred bonus payments can be unlawful in circumstances where they defer an earned payment beyond 1 month or outside the month in which the payment was earned. That's because at law, an employee must be paid in full in the month in which they earn an entitlement. So what we have done in response to that decision is to proactively enter the clause to make very clear that for the purposes of the clause, the actual payment is only earned once various conditions are met, and therefore we can ensure ongoing compliance with the Fair Work Act through the use of these contracts. I think most other employers that are using static templates or sort of relying on going and engaging lawyers to review contracts, for example, would have to wait for that process to be complete before compliance is assured. And in our approach of ongoing compliance, that is already dealt with.
Thanks, Steve, so much for explaining essentially the core differences between direct employer contracts and staffing contracts and the clauses that we would typically see in those contracts, and also for that really great example of how we maintain ongoing compliance by keeping the clause library updated. So for anybody who's new to the Contract Builder, actually, so Contract Builder is a feature that's been in Xemplo for a while. We haven't had staffing clauses in the library until relatively recently, though. As different clauses or employment requirements are changed, our employment law team actually updates all of these clauses, and you'll get an automated alert to let you know that the contract has been changed, so that you can continue to use compliant contracts without any additional effort of your own. So that seems like a great time for us to now turn our attention to. We've had a look at essentially what service agreements and staffing contracts are, how they work within Xemplo, and how you would use them. Now it's time to talk a little bit about the benefits that they offer all of the parties involved in essentially the employee onboarding process. So the candidate, as well as the client, as well as the employer as well. So Steve, do you want to share the reasons that businesses would use employment contracts in this way and what the benefits would be for an employer in their relationship with a candidate from using an employment contract in this style?
Look, I think it's trite, but the obvious starting point is that all workers should have a written contract with their workers. And this is the case regardless of whether it's a direct or contingent worker relationship or the worker is an employee or independent contractor. And the reason for this is because the working relationship, although there's lots of new statutes like the Fair Work Act and old statutes like workers' comp laws and the like that apply to them, the relationship itself is still fundamentally based on contract. Every worker has a contract, and it can either be a handshake, it can be an oral agreement, it can be an applied agreement, or it can be a written agreement. Needless to say, having the written agreement clearly expressed means disputes are far less likely to arise with workers, and they are far easier to resolve when they do. You just defer to the written agreement. In this industry, I think they're doubly important, though, for a handful of reasons. The first is there are really unique features of contingent work arising from the fact that it occurs in a labour supply chain, and we've already mentioned some of those features. I think the second reason, and this is massively understated, but really does underscore the importance of using a tool like Xemplo, is that staffing providers, they're not just there to sell convenience to their clients, they are selling compliance to clients. So it's really important, I think, for staffing providers to be able to show their clients that they are engaging employees or workers on contingent contracts, and actually what the process behind that is. That's becoming more and more important now that we are in an age of criminalised responsibility for underpayments and massive civil liabilities that arise for breaches of payment laws and other aspects of the Fair Work Act, especially where those fines and penalties can even be extended to third parties that were knowingly involved in the breach. So having the ability to demonstrate compliance to your clients is critically important. I think just thirdly, I've mentioned this previously, look, inevitably things can and do go wrong between workers and hosts or suppliers and hosts. So clear terms that allow everyone to get on the same page when things go wrong is really, really important from a legal point of view as well.
Thanks, Steve, for those insights about employment contracts. Now looking at service agreements, I'm just going to reach out to Tim here on the call. Tim, in your building of the service agreement product, which is a relatively new feature to the Xemplo suite, what are some of the reasons that the customers you're working with who are building out the feature sort of highlighted that they needed service agreements for managing their relationship with their clients?
Yeah, thanks, Ray. Look, it was a real mix when we started working with initial clients on solving this problem, or even before that, I should say, defining the problem. The way that clients out there in the market were dealing with service agreements was fairly mixed. Some weren't sending out a service agreement on a per assignment basis. They were sort of relying on an underlying agreement that they'd made with the client at the start of their relationships, but they weren't sending out anything on a per assignment basis, which was delving into the specifics of the engagement with that particular worker. So as Steve just mentioned then, there are differences in a case-by-case basis with different workers that you're engaging, stemming everywhere from the type of work that they're doing or things like those bonus stipulations. Those things weren't necessarily being put into an agreement and sent to host clients on a case-by-case basis. The other scenario was that they were sending out an agreement, but they were typically using a third-party system to send out that agreement, a document signing system, for example, which was incurring additional costs to the business, but also additional admin overhead because they're having to manage a whole other system in silo. And thirdly was the scenario where they might have had all good intentions of having a process set up, even if it was just sending an agreement via email, but because it wasn't tightly bound to a process flow, and was documented. It was something that was typically falling off the process and not being sent at all, which obviously introduces significant risk. And while you can have all of the good intentions to send it, if you don't send it, then it doesn't exist, and it's not saving you from anything. So at the core of, I guess, what we found, or the common theme that we found by working with these initial clients, was that service agreements had to be very much embedded into the process flow. And that was where we identified the fact that, it needs to be as important as sending out a compliant employment contract and getting the worker to complete their side of the equation. So that's why with Xemplo, we took the approach of looking at the post ATS flow. So if you are using Bullhorn or JobAdder or another ATS, what happens within that gap prior to the worker being onboarded? And that's where we looked at the problems that existed and how we could best solve them with a technology platform. So we very much looked at it solving the process side of the equation, but from a legal perspective, Steve, is there anything that you'd like to add with regards to the contents of the agreement, more so the process that's undertaken?
Yeah, thanks for that, Tim. Look, I think I can say pretty simply that there's a real benefit in going through this process because it creates certainty and clarifies expectations for all parties. I think that's the primary benefit and where the terms of these agreements need to go to. So if you look at it from the point of view of, the different parties who are involved in, these supply chains, from the host's point of view, they're signing off on the terms of the engagement. So they're committing to payment terms and any minimum engagement period. Within that, you can secure agreement around what happens in the event that an engagement comes to an end earlier. That's, really important when things go wrong. And I would say, in addition to all of the standard things that you do need to agree to, like charge rates, role description, location, hours, supervision arrangements, and what any kind of specific site obligations exist. So, at the end of the day, as an agency that your client for each and every engagement has specifically agreed to your terms, and you can rely on that. From the employer's point of view, they only proceed to onboard a client once a client has accepted that engagement. We know as advisors and service providers in this industry that there can be a lot of pressure on agencies to onboard clients quickly, and oftentimes there is pressure to onboard clients before these assignment terms and conditions are signed off. By creating, a clear flow, consistency of terms, and the simple ability to push those service agreements through to hosts or clients through the tech means that staffing businesses are far more likely to be relieved of that pressure of trying to be forced into commencing an engagement before the terms are accepted. That ultimately means, there's legal protection for you, the agency, because you've got clear boundaries around the terms, particularly around things like supervision, liability, and payment. Then if you sort of want to focus or home in on, the specific benefits of doing it through the technology, you can avoid common disputes around precisely what was agreed because you've got a digital audit trail of everything that's occurred and precisely what those terms were. So some of the things that you do see in disputes, even where there is a written agreement, is what version of the written agreement was signed off on, and those sorts of things don't arise when you're using a feature like this. So it's essentially very, very helpful in the event that something does come up between the parties where there is a disagreement to solve.
Thanks very much for that, Steve, for those insights into service agreements and how they all protect your relationship with your client. Throughout the call so far today, we've talked a lot about risks in relation to the benefits that you can achieve with using through a better process for managing employment contracts or service agreements. Just to summarise some of those risks clearly, Steve, do you want to tell us about your top 3 common risks that you think an employer is potentially exposed to through kind of poor contract or service agreement management processes?
Quite obviously, the biggest risk is when there are instances of non-compliance in contracts. Where there is non-compliance, that can lead to, claims made by workers. It can lead to additional time, costs, and effort around termination. Where that occurs, you can end up in dispute, and that can lead to damage to your brand or damage to your relationship with the client and a breakdown in trust. Obviously, in the worst case, non-compliance can lead to significant fines, or in the case of underpayment, in the era of criminalised underpayment, even criminal sanctions. So non-compliance is obviously still really significant. I think that there's obviously just a practical risk around contracts becoming outdated. That adds to the risk of non-compliance, but outdated contracts are also, I think, a bad look for business, particularly when it's clients and employees who are pointing out to employers that there are issues with their, contracting documents and those types of foundational arrangements. So you really want, both from a compliance point of view, but also from a brand and good business point of view, to ensure that your contracts are not outdated. I think finally, just sort of circling back on what is the outcome of non-compliance. I just can't underscore enough that once upon a time, with complex arrangements like awards, enterprise agreements, the Fair Work Act, there was a tendency to honour them in the breach and not in compliance. And that was because it was very hard for workers, perhaps at one point in time, to get information on what their entitlements were, or it was less likely for a regulator to inquire into your business and whether or not things were being done correctly or not, or clients may not have been as interested in your compliance. I think that's all out the window now. I think in the regulatory environment where there's a really well-funded Fair Work Ombudsman on the beat looking to ensure compliance, where workers have so much access to information about their rights and entitlements, and where the fines for getting things wrong are just so big, you really cannot avoid trying your very best at all times to ensure compliance.
Thanks, Steve, for sharing those common risks for employers in the process. It's going to be a hard one to follow up those, Tim, because there were fines and all sorts in there. But what sorts of risks do you think that employers need to watch out for during the onboarding process in relation to contracts and service agreements?
Yeah, look, a very difficult one to follow up, but I'll certainly try my best. It's I think if we start off with the first being just around documents not existing in the first place. So if either your process of engaging new talent either doesn't include a step that involves obtaining those documents from those signed off documents, I should say, from your host clients, or it is in the process, but it's sort of loosely bound so that there's the opportunity for that step to be missed. The net result of both scenarios is that you've got missed documents in your library of compliance documents within your organisation. As I said, unless it's something that is within your process flow and is consistently done that way every time you have a new assignment, there's always the opportunity for those missed documents to exist, and then you've sort of got holes in your compliance. I think the second part is around the overhead that's involved with sending those documents. So if you have all good intentions and you've got it as part of your process flow, if the step of creating those service agreements, sending them out to the client, obtaining that sign off, and then proceeding to the next step is quite a timely exercise, or includes a lot of admin work to do, then typically it will be either skipped, or it does create what I've got as the third thing, a number of delays, which can affect your ability to service your clients, especially if you're on a growth trajectory as an agency and you are getting more and more assignments coming through the door, the part of the process where you do send out that service agreement, it can't represent a friction point within your process. If it does, then it is going to be something that has an effect on how you service your clients, how you ultimately onboard your workers. If you do have it as a sort of gated step in your process flow, having that as a slow piece of the puzzle is ultimately going to slow down your onboarding of the worker. If you're an agency that's working in quite a competitive market and that talent might be looking at a number of different opportunities at the same time, if you're delaying getting that contract sent out and getting it signed off due to the service agreement step being slow, you have the potential of losing that talent. And in particular, if your host client has invested a lot of time in finding that person, you're going to have an unhappy customer. So, reducing those delays at the same time, and it is a balance to get right with your process flow, is imperative in also making sure that you're compliant with getting these agreements signed off.
Thanks, Tim. I think you might have stolen a couple of my three, but that's okay. I'll actually probably just extrapolate on a couple of those in my three, which are a bit more candidate focused. I think the key risks that we potentially run into from a candidate perspective is about the experience, as you've highlighted there. The process of when you accept a new job as a candidate, it's obviously an exciting time. You want to get through the process of onboarding somebody as quickly as possible. So talent can always go back to the market if the onboarding process is perceived to be too slow or too confusing, or there's any uncertainty in there. And uncertainty can come through things like not having an agreed service agreement in place with the candidate, who then might change their mind about the nature of the role, the tenure, anything about the engagement, which then of course throws the candidate off. So you're at risk of a poor candidate experience there, which will then turn into a poor brand reputation for you. So if you essentially become known for a clumsy process amongst the candidate community, especially if you're in a really niche market, for example, which a lot of staffing providers will be, and especially one that's tight for talent, you definitely don't want to get the reputation as somebody who potentially doesn't have their ducks in a row when it comes to onboarding new candidates, particularly in talent markets. So the third one I would highlight there is very similar to Tim's. It's about client experience in relation to candidates. If you lose candidates through a poor onboarding process or through administrative errors of your own, when the client wasn't involved, obviously that's a poor experience for both the candidate and the client as well. You've basically lost talent that they potentially secured for you, or you've gone through the whole process of finding talent together and then sort of not being able to actually get it across the starting line is a disappointing outcome for both the candidate and the client, and then ultimately yourself. So this is probably a good opportunity for us to transition into how we can solve some of these problems in Xemplo. So we have had a look at how we create staffing contracts and keep those compliant throughout your use of Xemplo, as well as how service agreements are created and incorporated into your onboarding process within Xemplo. So just to highlight a few of the core benefits again, I'll throw back to Tim, who's going to tell us all about service agreements, and then we'll talk about contracts after that.
Yeah, thanks, Ray. Look, from Xemplo's perspective, as sort of noted earlier, we do have the ability for you to load up your service agreement templates into the application. And the most common place where those are then surfaced is in our ATS integrations. So with Bullhorn, for example, we have a custom tab that you can open up from the placement screen, which is a really important part of obviously the front office process. Once you've got that worker to a placement point, it's ready for everything downstream to start to happen. So Xemplo plugs in at that point. It surfaces a list of all of the service agreements that you've previously uploaded into Xemplo. It does that directly into Bullhorn, so you don't have to jump between the two systems. It allows your recruiters or your consultants to select the template that's the best use for that particular placement. So you can have one or you can have many. And once you've filled out all the other required things on that tab, such as the pay rate, the charge rate, and you can use our built-in calculator to determine those final rates before you move forward, it actually gives the consultant/recruiter a preview of that service agreement in a rendered form. So as I was saying earlier, we can gather a whole lot of data from your ATS we can pull it in and merge it dynamically into that contract so that they can see the document in its full entirety before it gets sent out to their host client. And we've got some other tricks where they can jump in and edit the email that's about to be sent out to who is essentially their client to get sign off. So it does embed that service agreement requirement right in the middle of the process flow, and the system can actually stop the process from proceeding any further into onboarding until that service agreement sign off has been obtained. So if you're either managing a team within a staffing agency, or if you are the owner of the staffing agency, you can sleep reasonably well at night knowing that onboardings aren't being sent out to workers until you've gotten that sign off from your host client, which is obviously stipulated all of the specific terms of that particular worker assignment. So we cover, I guess, a lot of bases. As I said, typically are handled by third-party systems. We sort of eliminate the need for you to jump out into a third-party system to generate that service agreement contract. Eliminate what typically happens is a lot of copying and pasting of data between those two systems from your ATS. Because we tap directly into the ATS, we can gather and generate that document really quickly and easily.
Thanks, Tim. And now following up with some of the key benefits of contracts within Xemplo. Using the Xemplo Contract Builder, we do a lot of the work for you in terms of compliance management. So we provide a library of clauses that are specific to the staffing industry or contingent workforce management that allow you to manage the expectations of both clients and candidates within the one employment contract. We also manage the ongoing compliance of those clauses. So whenever there are changes that impact a clause, such as the ones that Steve mentioned earlier with regards bonuses, the recent changes to the Fair Work Act, for example. We basically, with our employment law team, keep those clauses up to date so that you don't have to. So that's one of the sort of the underlying foundation of the contract builder that makes it a really fabulous feature for our customers. Probably the other thing I would highlight in relation to contracts is we provide the clauses and the shells of contracts, and then within that you create your company-specific configuration. So it's not one set of contracts that fit all employers, because that's not realistic. It's basically a contract that will give you guardrails within which you can create your own company-specific rules and preferences, which is really important. It's an acknowledgement that compliance is an essential for all businesses, but there needs to be a level of flexibility so that you can address situations that are specific to your own business as well. So on that subject, Steve, have you got any other final insights that you'd say about the way we manage contracts or service agreements within Xemplo?
I think it's just to reinforce the importance of proactive compliance. Throughout my career have typically worked for law firms, and the approach that those advisory businesses take when things change is to put out alerts to their customers and to invite their customers to come back to them and to pay a fee to them in order for them to update assets that are relied on in the business to employ workers and ensure compliance. And there's a great deal of cost involved in that, but there's also a significant opportunity for compliance to be missed, because if you don't go back to the advisor, you don't get your documents updated. In our case, we really are proactively managing that compliance so that when there are changes, and in Australia, if we just focus on our domestic market, there's been something like 30 changes to the Fair Work Act over the last 2 years. There really is a need to have a constant eye on change. And so when it comes to updating contracts to deal with, for example, this recent federal court decision dealing with bonuses, to deal with changes to the way casual conversion flows work, things like the introduction of right to disconnect laws, which present a unique challenge for contingent workers, changes to how public holiday working rules are determined, and the beat goes on with all of these recent changes that we've had. If you don't have someone proactively managing that, it really just is inevitable that at some point your contracts will fall out of compliance. And when compliance is what you are selling, you are exposed to a risk with your customers, but also your workers. So there's really a double threat there. So just really cannot, I think, underestimate the importance of the way we're doing things here proactively, as providing a significant benefit to anyone that's involved in the contingent worker employment market.
Thanks very much, Steve. And that brings us to the end of today's presentation. I want to say a huge thanks to Steve and Tim for sharing their insights today about employment contracts, service agreements, how staffing, contingent workforce, client-based, project-based workforces and employers are able to use these to streamline their onboarding of clients and candidates. So from here, existing Xemplo users, you'll be able to explore both of these features inside Xemplo now. So please follow the in-app guidance for creating a new staffing contract using the contract builder. Likewise, there is information about how to create a service agreement available from our support portal and also from the Xemplo website. If you need more assistance with configuring either of these features, please reach out to us for a walkthrough or a demonstration, and we'll be able to point you in the direction of the assets that will help you to get these set up. For non-existing Xemplo customers, please feel free to find out more about these features from our website, or to book a walkthrough or demo, which can also be done through the website as well. Thanks very much to everybody for watching. We look forward to seeing you at our next webinar. We've got another one coming up in a month about performance management in Xemplo. So thank you very much, and we'll see you at the next webinar.